more scheming, more altering, more changing things up in order to fit your agenda. What was her agenda? For Martin Peterson to go to prison and die. Welcome to Jurors in Disguise, the podcast that exposes liars. My name is MaryRose Peterson, and I own Covert Ops Jury Investigations. We are hired by those who've been convicted to find the jurors who were biased and lied during jury selection, denying them a fair trial. People ask me all the time, how did you get started investigating jurors? So I've spent the last several podcasts explaining a little bit of our story and how I watched the movie Runaway Jury, and that inspired me to look into our jury. So I've talked about that in previous podcasts. I've talked about some of the players in the case. I have exposed not only the jury foreperson and her lies, but the lies by Martin's ex-wife, his daughter who falsely accused him, and the daughter's best friend who testified against him at trial. In this podcast, I'm going to expose the mastermind of the scheme that wrongfully convicted an innocent man and put him in prison for life. Judge Erin Corcoran Daly. But she wasn't always a judge. In 2012, she was the prosecutor who fabricated a case where there was no case. So let's begin. On April 19th, 2010, Deputy Rick Kramer came to my husband's home. And I know if you've watched the other podcast, you'll know a little bit of this story, but I feel there needs to be some overlap. When Martin's then-wife met Deputy Kramer outside the house without waking Martin, she gave him 2 notes that their daughter had written. She showed him first a purple note. Actually, it was written in purple ink. And then she showed him a note written in blue ink. I have covered them up for obvious reasons. It's not important for you to know what he was accused of, but it's important to understand that the first note was written in purple, the second note was written in blue. And you'll see here on the side, it has RK1, Rick Kramer 1, 2010, and a number there. Then on the bottom of this one, it says RK2. So clearly that's how they were presented. And in his police report, he noted them RK1, note in purple ink, RK2, note in blue ink. The next morning, Martin's then wife and daughter showed up at the sheriff's office, and they gave written statements outlining all of the accusations of Martin. Then the daughter had said that she had told her best friend, who, as I've mentioned, became the outcry witness at trial. So Deputy Shane Landgraf, who was the school resource officer, pulled this kid out of class and told him what was going on and asked him to make a statement, writing down all the accusations that Martin's daughter had supposedly told him several weeks before. So he did. He made a statement. Now, I'm desperately trying not to confuse you, but remember, purple note first, blue note second. Okay, so according to the accuser, this is the note that she gave her best friend. However, when you read her best friend's statement, it matches everything in this note and mentions nothing about this one. Now, why is that important? Well, my opinion is that this was being made up as they went along. It's what it certainly appears to be, which could explain why his statement didn't match the note that he said that he saw. So fast forward nearly 2 years when everyone was being deposed right before trial. During the deposition of the outcry witness, he was shown the purple note, RK1, and asked if he had ever seen that. He said, yes, that's the note that the accuser showed him. Then the prosecutor, Erin Daly, showed him the blue note. And he said, I've never seen that. Never saw that before. Well, that's interesting. So how is it that your written statement matched this one, but now you've just admitted you never saw this one? He also admitted during the deposition that the evening Martin was falsely accused and the next day when they were at the sheriff's office that he and the accuser were texting back and forth. Did she accidentally text him the wrong note and say, vouch for me? Can't prove it, but that's my thoughts. So next, the accuser was deposed, and she said, "This is the note that I gave Todd, and this is the note that I showed only to my mom." So, as has been previously demonstrated, this kid was getting the stories mixed up from the very first day. So now we've got the notes in backwards order. So immediately following the Outcry's deposition, in which he identified the notes as that's the one he saw, that's the one he never saw. Immediately following that deposition, the accuser was deposed. Now, when they got to the notes and Aaron Daly was showing them the notes, she showed her this note and said, "This is the note that you showed your best friend, the Outcry, right?" And at first she said yes. And then she said, "This is the note that you wrote and showed to your mother." And then the accuser said, "No, no, no, no. This is the note that I showed Todd. And this is the note that I wrote afterwards and gave to my mother." So immediately, right off the rip, in pretrial depositions, Aaron Daly knew these kids were getting the stories mixed up. So after these depositions, prosecutor Aaron Daly, assistant state attorney Aaron Daly, knew she had a dilemma, because going into trial 2 months away, these two witnesses, her two key witnesses, were identifying different notes. Their stories didn't match. So what did she do? Did she drop the charges? Did she say, I can't proceed with this because I can't guarantee that my witnesses are being truthful, and right now it certainly looks like they're not? No, of course not. She proceeded to trial, but she had to scheme to defraud before she got to trial. So what did she do? Well, I'm going to tell you what she did. She took the two notes, the purple note and the blue note. She erased Detective Kramer's initials and identification marks. She reversed them. So now the blue is first and the purple is second. Why did she do that? So they matched the accuser's and the mother's testimony. But keep in mind, now they didn't match the Outcry witness. She marked them states A, states B, copied them in black and white, and entered them for identification purposes only, not as exhibits. Because why? Because then when the jury wanted to see the notes, which they did, they weren't allowed to because they were not officially entered as exhibits. Again, schemed. This was calculated. This was thought through. This was intentional. Then she filed an amended information saying, under penalty of perjury, that she has, in good faith and subscribed under oath, certifying that she has received testimony that the material witnesses are being truthful. She knew they weren't being truthful. This was a false document, but she filed it with the court right before trial. Then, as you will see on her exhibits for identification and evidence, this is the document that she filed. There's her signature in yellow. Note from JP in blue ink is Exhibit A. Note from JP in purple ink is now states B. So they're backwards. During trial, she only showed the notes in backwards order to the accuser and the mother. If she had shown them to the Outcry witness, what would he have said? They're backwards. I never saw this one. But then again, how is it that his statement to Deputy Landgraf matched the blue one that he repeatedly said he never saw? Again, schemes, stories, lies. Then during her closing arguments, she said things that I sat there and was absolutely horrified. She said to the jury, "If you believe the victim, the defendant is guilty. I'm sorry, I thought you were innocent until proven guilty." It's not a church service. It's not what you believe, but that is what our courtrooms have been reduced to. Game shows. If you believe her, if she puts on a good show, then he's automatically guilty. She said that 3 times. The defendant is guilty. If you believe her, the defendant is guilty of lewd and lascivious molestation. You get to A on the verdict form, you find him guilty. You check that box. If you believe that they occurred to her on one or more occasions, then the defendant is guilty. It doesn't matter if it happened 1 time, 2 times, 15 times, 1,000,000 times. Well, I'm sorry, Ms. Daly, but it certainly mattered to me. Once or twice is not the same as every day for 5 years, but only between 4 and 5 in the evening when you're at the YMCA and after school care and Martin Peterson is out driving on the road from one state to the next, not even in Florida, and never on a weekend and never during the summer. That was the accuser's definition of when these things happened to her. Well, I think that matters because that goes to credibility. But she already knew she wasn't credible. Then she said if she's truthful about getting touched by in the improper, illegal sexual way, then there is no reasonable doubt. Well, how do you know if she's being truthful? Because we already know that Erin Daly knew she wasn't being truthful, and she put her on the stand anyway and then vouched for her repeatedly. These are just closing arguments. She vouched for her all through trial. Then she said, and it's almost laughable when you look back at the other podcast where I outlined over 200 lies by Erin Daly's witnesses. She had an accurate memory, she said. She obviously has some issues, but she knew very specifically what happened to her and what didn't happen to her, what didn't happen, things that she was very clear about. She knew details about the crimes enough that you can determine that she accurately remembers these things happening. My God, she's already got the notes mixed up, Erin Daly. She doesn't remember anything accurately. More lies. Then she said, the burden of proof is on the state attorney's office, and we've met that burden. These are not stories that are being told to you. These are facts, and these facts are in evidence. Quote, she was honest and straightforward when she answered the questions. She's been consistent. She came in, she took an oath, she clearly understood. She might not be very sophisticated, but she understood and promised to tell you the truth. She has nothing to gain from being here today except embarrassing herself. Really? She has no incentive to lie, she said. Really? And then she said, it wasn't her mother who put her up to this. Now, see, is that a Freudian slip? She gave very vivid details. They're not inconsistent. Well, isn't that interesting? Because when I showed that chart to the detective, he admitted there was no consistency to her testimony. She was completely inconsistent, as did Steve Gosney. Attorney Gosney testified that he actually filed the appeal and wrote a chapter in his book talking about how inconsistent and contradictory this accuser was. Erin Daly said she remembers the specific things that happened to her. That's all consistent. Have you noticed how many times she said consistent or not inconsistent? She saw what happened. She reported what happened. And I ask you to go back and find him guilty of everything that we've charged him with. This is my favorite quote. She's not sophisticated enough to pull off this elaborate scheme to get away from the defendant. She told what happened to her. She didn't exaggerate. Well, maybe she didn't, Erin Daly, but you sure did. Fast forward nearly 4 years. So Martin got convicted, went to prison, and we spent a total of 4 years, 2 months, and 13 days in prison. Remember, with a life sentence, no chance of parole. Over all of this, after showing Judge Merritt all the juror misconduct that we uncovered by our foreperson, Rose, he ordered the voir dire to be transcribed. It had not been transcribed up to this point. Now, remember, voir dire is a fancy word for the jury selection. So he ordered that proceeding to be transcribed. I later found out when I spoke to the court reporter that she had hand-delivered it to Assistant State Attorney Aaron Corcoran Daly. That was on April 7th, 2016. 2 weeks later, Aaron Daly filed the court reporter's transcript with the clerk's office. Now, standard protocol, I'm told, is you file it immediately, maybe the next day. But she waited 2 weeks. Why did she wait 2 weeks? I'm about to tell you. What she didn't know was that I used to type for court reporters 40 years ago. I know I'm old. And so I knew to reach out to the court reporter after trial, and I said, I need a copy of the audio proceeding, the audio of the jury voir dire, because it was not typed out. It was not ordered to be typed out. Courts often exclude the jury voir dire proceeding from the transcripts because the state has to pay for it. And in my opinion, it should always be transcribed. They consider the jury selection the first part of the trial. That's when the trial begins, is when you select the jury. So why do judges not order that proceeding to be transcribed, knowing that anywhere from 2 to 10 years later, the court reporter is going to destroy that record because that's what they're legally allowed to do? So now you have no record of what was said. My opinion, it's suspicious. Again, it's a setup. But here's what's interesting. Erin Daly did not know that I had the audio of that proceeding. She knew I was there, but she counted on me not remembering things accurately 4 years later. I had the audio. Now, what I had also done is taken that audio to a local court reporter that worked independently, and I had her transcribe it for me 3 years before this particular time. So not only was I there and knew what was said, but I also had the audio and an official version of the jury voir dire transcript. Now, in the first original version, we got through jury selection. The jurors were excused, and we began the balls and strikes, as they call it. We began to pick who we wanted for the jury. I found it interesting that Martin's attorney and Aaron Daly, the prosecutor, and Judge Merritt, when they got to each person and they described them, they talked about what they were wearing. They talked about the things that they said, what they did for a living, whether or not they wanted them on the jury. When we got to the foreperson, Rose, nothing was discussed. It was simply asked of the state, what do you say on Juror 53? And I looked over at Aaron Daly. And of course, like I said, at that point, we wanted her on the jury because I thought she was pro-defense. She'd given that speech. So I was holding my breath that they wouldn't object, and she didn't. Aaron Daly said no objection. And I was like, yes. Judge Merritt had no objection. The state had no objection. Martin's attorney said, we'll take her. I thought, we're gold. We've got this. We're going to win tomorrow. Well, we get to the end, and there were 6 jurors chosen and an alternate. Martin's attorney raised her hand and said, can I ask a question? And I've said this before in a previous podcast, but the judge said yes. And Ms. Kavanaugh said, am I missing something? Or are we supposed to have 12 jurors because it's a capital case? And the judge said, no, not on this. Now, that's what actually happened. And that's when, if you may recall earlier in another podcast, I looked at Martin and said, oh, we're in trouble here, because we turned down the deal being assured there would be 12 jurors. And it's obvious from his attorney, she was just as shocked as we were that the court had decided to only have 6. Now, here we are with this new transcript that Aaron Daly had presented to the clerk. And in her version, it has her speaking. And she said, may I ask a question? The court, yes. Then Ms. Daly, in this new altered transcript, said, am I missing something? It almost looks like 12 jurors because of the capital. What? It almost looks like 12 jurors. We'd only pick 6. The court said, no, not on this. And then the altered transcript, Ms. Daly says, no, only 6. And then she has Ms. Kavanaugh saying, okay. Not only is that not even close, that doesn't make any sense. Now, why Did she take 2 weeks to alter that little small portion? I'm not an attorney. I'm told it's fundamental error. Martin could have gone back and possibly gotten a new trial based on that because he was assured when he turned down the deal there would be 12 jurors, not 6. And Judge Merritt did not stop and say, Mr. Peterson, were you aware that you would only have 6 jurors? Now, again, I'm not an attorney, but last week I did speak with attorney Brian Savy, and I asked him the question. So if you didn't watch last week's podcast, go back and do that because he will have explained that better than I can. But I found it interesting. Again, more scheming, more altering, more changing things up in order to fit your agenda. What was her agenda? For Martin Peterson to go to prison and die. So we went to the evidentiary hearing, and our attorney, Brian Savy, as you may recall from last week's podcast, started negotiations with Erin Daly, who ultimately held Martin's freedom for ransom and said she would agree to a plea that involved 1 count of felony battery, time served, and another count of felony battery where he would have to do 5 years of probation. Now, to us, not only was he going to be coming home that night, but he would be immediately removed from the sex offender registry, so we were thrilled. In fact, I have the plea agreement here. This is actually what was said in court, and it's kind of messy, but that's what was handwritten by the judge, and that's the things that we agreed to in court. We agreed on a plea. We went back into court. The plea agreement was read into the record, and there were notes taken. This is the first initial handwritten plea that everyone had agreed to, and it shows felony battery, 5 years of probation, time served. It shows that credit for money's paid. The court has no objection to him being released from the jail. It has all these things: set aside and vacate previous conviction and sentence. And he may travel for work purposes, because remember, Martin was an over-the-road truck driver by trade and intended to go back to that. So this is what we agreed to in court. From that, they typed a 4-page official waiver of rights and plea agreement. You'll notice on this plea agreement, it says unofficial document. I have the original certified copy, but for the purposes of this podcast, I chose to present this one. This was simply downloaded off of Martin's docket, and you'll see we even had included it as an Exhibit N, and you'll see the 6 sexual battery charges were replaced with the 2 counts of felony battery. It had all kinds of stipulations that we had agreed to, with certain things that we had not agreed to that you'll see are handwritten by the judge. So we did that. Martin initialed that he agreed to all these things. The very last page has Martin's signature, Brian Savy, our attorney's signature, Aaron Corcoran Daly's signature, and Judge Merritt's signature. That was on July 28th, 2016. This is the plea agreement that Aaron Corcoran Daly offered and was to honor, but she didn't. After leaving the courthouse that day, I went straight to the jail because I knew that Martin was going to be released. Shortly after that, he was. And if you go to our website, juryinvestigations.com, you'll see a really cheesy video of me picking him up at the jail. He's coming out back from being escorted by the sergeant, wearing paper clothes, and you will see that there weren't words. That was a celebration. We went from life sentence to we're sitting around at the hotel by the pool eating pizza that night with me and my adult children and Martin, just praising God and being overwhelmed at what not only he did, but the fact that we were sitting around a pool eating pizza with Martin. No ankle bracelet, no handcuffs, no guards standing over our shoulder listening to what we said. Just sitting there laughing and talking and praising God. That was that night. Because he had agreed to probation, we had to report to the Brooksville Probation and Parole Office because he had to report in. Remember, he had agreed to 5 years of probation. He could early terminate in 2.5, so that was our plan. We were going to do everything right, jump through all the hoops, and be done in 2.5 years. It's like, we can do this. And the judge had already agreed to let Martin go back to work driving over the road. And of course, I was going to ride shotgun. I was never going to let him out of my sight ever again. So that's what we went to do, but we had to first report into probation and parole, and we did. When we got there, we were immediately escorted into an office of a probation officer who was in charge of sex offenders. Martin and I immediately began to protest and said, "No, he pled out." You'll know if you have or had someone in prison, you will know that you feel that when they put the handcuffs on them, you feel like they might as well have put them on you too, because you feel shackled. You feel that you're in prison. You're doing time right alongside them. It's not the same, but emotionally and mentally, it is. So I know I say we and our case and all of those words that are inclusive because it was a part of me from the beginning. So we immediately began to protest and said, "No, no, 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 no. This is this is what we pled out to. This is what we agreed to. Felony battery, felony battery." Now realize we didn't have a copy of this because they hadn't given him one. I should have made sure that I asked for one before I left the courthouse. I did not think at that point in time. Remember, all of these things that we found out about Aaron Daly were found out after all of this point. We didn't know all of this. We didn't know about all the sneaky business and the scheming and the lies and the altering of transcripts. We didn't find that out until later. So I didn't think I needed to hold her feet to the fire, as they say, and demand a copy of the plea agreement. But this is what we walked into: sexual battery upon a child under 18 by family custodian. Again, somebody altered that plea agreement and turned it into this one. It was not what we agreed to. The special conditions were different. All of the handwritten things by Judge Merritt weren't there. Martin was fitted with an ankle monitor and was read the riot act. These are the places you will and will not go. These are the places you will and will not visit. You can't live within X amount of feet of a church or a school. You can't go this, you can't go that. We were absolutely horrified and stunned. We spent the whole day protesting that this is not what we agreed to at all. And it needed to be fixed because we were about to drive back to our home. At that point, we were living in Perry, or I was living in Perry. Martin was going to come live with me, of course. And that was about a 6-hour drive from Brooksville. So we were going to go back to Perry, where I had been living while he was in prison. He had been incarcerated at Taylor Correctional Institution, and I lived about 20 minutes from the prison. I moved there intentionally so I could visit him every weekend. So the probation officer supervisor was Samuel Flynn. I believe he's still there. I'm not positive, though. I know that Mr. Marrero, the probation officer, has retired. But Samuel Flynn said that he had spent all day on the phone back and forth with Aaron Daly trying to get this corrected back to this. Didn't happen. At the end of Friday, it still wasn't corrected at all. Now, that made no sense to me. I said, it's simple. You just get what we agreed to and you retype it. This is wrong. What is the problem here? Well, we had to stay in Brooksville for the weekend. We went back on Monday and were informed that Aaron Daly was refusing to fix it. She would not honor her agreement. We had to go back to Perry, and here we are, ankle monitor, sex offender probation officer, and she was female, which didn't make it any easier because Martin was terrified at that point of being alone in a room with any female. You can imagine why. We, of course, immediately called Brian Savy, who did his best to try to course correct this. In the end, there were 4 more order of probations, and Samuel Flynn and Brian Savy had tried to work with Aaron Daly to fix it and honor the agreement that she said she would honor in court. It was never corrected 100%. It got to the point where it was something we could live with. So we did. Wasn't going to be easy because Martin was still wearing an ankle monitor and would still be assigned to a sex offender probation officer who was now requiring that he go into treatment. I'm not even going to discuss the things that sex offenders who have been convicted, whether they are guilty or not, have to endure when they go into these treatment programs. But disturbing on a level that I can't even describe. The things that they have to sit and listen to. And then if they don't admit and they don't talk about what they did, they're violated and they go back through the court system with the goal of putting them back in prison. They're forced to take polygraphs. And according to the men in the class, that you never pass a polygraph until your time is almost done and you're about to get off probation, then suddenly you pass. It's just another setup. It's just absolutely another setup. But we did our best to maneuver these waters of probation. And what happened 8 months later was that this probation officer decided that she didn't like Martin. She never liked me. She had been flirtatious with him. She had told him at one point that when you tell your wife that you really did molest your daughter, which was a requirement of the program, when you tell her that and when she leaves you, you can call me. She handed him her business card. How do I know that? Because he gave it to me when he got back in the car. And he said, I don't understand why she gave me her card. I've been a probationer of hers for weeks. I already have her number. But she said, you can call me when your wife leaves you. 8 months later, she filed a false police report saying that Martin had done things he had not done, could not be proven. And in her recommendation, she asked Judge Merritt to put him back in prison. Until next time, if you know of someone who was convicted by a jury and needs our help, you will find our contact information in the description below. Again, I thank you for watching. And remember, the courtroom may be silent, but we won't be. So speak up, speak out, and always speak the truth.